here's where I ask them to admit or deny the Montana Constitutional Article 2, the Declaration of Rights, Section 1, popular sovereignty. All political power is vested in and derived from the people. All government of right originates with the people, is founded upon their will only, and is instituted solely for the good of the whole. Action of Second Continental Congress, July 4th, 1776, the unanimous declaration of the 13 United States of America. We hold these truths to be self-evident, that all men are created equal, and that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. This is key. The United States is a corporation. This is from 28 U.S.C. 3002, subsection 15, section A, granted, limited, and enumerated powers over commerce. See United States Constitution, Article 1, Section 8, and consent to be governed is established by the sworn oath of a public servant as required by 5 CFR 2635.101, subsection B, CFR Part 3101, and 5 CFR 735. And as per the Federal Rules of Civil Procedure, Rule 2, there is only one form of action, the civil action, and is the original intent of Congress, and is confirmed in 28 U.S.C. 1333, 28 U.S.C. 1331, and 28 U.S.C. 1353 historical notes, which can only be commenced by a covered employee. That's from Title 2 U.S.C. 1408, and therefore can only be actionable against another covered employee. So, essentially, just so that we're on the same page here, you gotta be a covered employee of the government for all that to apply to you. Okay, and you gotta have been sworn an oath as a public servant in order to have given your consent to be governed. Okay, moving on. No one can give consent of another to be governed, as waivers of fundamental rights must be knowing, intentional, and voluntary acts done with sufficient awareness of the relevant circumstances and likely consequences. That's U.S. versus Brady, U.S. versus Odell. Okay, so I hope we get the idea of what it means to have the consent to be governed. Did you give your consent to be? Did anybody give their consent to be governed? That's what that section is. Reread that. Read that a few times. Okay. 28 U.S.C. Judicial and Judiciary Procedure, subsection 1333, Admiralty, Maritime, and Prize cases. The district courts shall have original jurisdiction exclusive of the courts of the states of, and then subsection 1, any civil case of Admiralty or Maritime jurisdiction, saving to suitors in all cases all other remedies to which they are otherwise entitled. And 2, any prize brought to the United States and all proceedings for the condemnation of property taken as prize. So if they kidnap you and bring you there, they're trying to take you as prize, right? Black's Law Dictionary, 2nd edition, defines admiralty as a court exercising jurisdiction over maritime causes, both civil and criminal, and marine affairs, commerce, and navigation, controversies arising out of acts done upon or relating to the sea, and over questions of prize. Also, the system of jurisprudence relating to and growing out of the jurisdiction and practice of the Admiralty courts. Also, the Court of the Admiral, the building where the lords of the Admiralty transact business. In American law, a tribunal exercising jurisdiction over all maritime contracts, torts, injuries, or offenses. 2 U.S.C., the Congress, 1408, civil action, the jurisdiction. The district courts of the United States shall have jurisdiction over any civil action commenced under section 1401 of this title and this section by a covered employee. 2 U.S.C., the Congress, 1401, what was just mentioned, procedure for consideration of alleged violations, filing and review of claims, except as otherwise provided. The procedure for consideration of an alleged violation of Part A of the subchapter 2 consists of the filing of a claim by the covered employee alleging the violation as provided in section 1402 of this title. 2 U.S.C., the Congress, 1402, initiation of procedures, the claim, the filing of the claim. 2, commence a proceeding under this subchapter. A covered employee alleging a violation of law made applicable under Part A of this subchapter 2 shall file a claim with the office. The office shall not accept a claim which is filed after the deadline applicable under subsection D. 2, contents of the claim. The claim filed under this section shall be made in writing under oath or affirmation, shall describe the facts that form the basis of the claim, the violation that is being alleged, shall identify the employee office alleged to have committed the violation, or in which the violation is alleged to have occurred, and shall be in such form as the office requires. Public Law 95-251, 95, the Congress, March 27th, 1978, 92, Stat 183. To amend Title V, United States Code, to provide that hearing examiners shall be known as administrative law judges, and to increase the number of such persons which the Civil Service Commission may establish and place at GS-16 of the General Schedule. Rodwell versus Rowland. Precedents are principles of law which are also conclusions or decision in a cause, and not a process of reasoning or illustrating. And in Olmsted versus United States, the makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred against the government the right to be let alone, the most comprehensive of right, and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. Justice Louise Brandeis cautioned, the greatest dangers to liberty lurk in the insidious encroachment by men of zeal, well-meaning but without understanding. And as per U.S. versus Throckmorton, fraud vitiates the most solemn contracts, documents, and even judgments. 37 jurisprudence, American jurisprudence, 2D subsection 8 states, in part, fraud vitiates every transaction and all contracts. Indeed, the principle is often stated in broad and sweeping language that fraud destroys the validity of everything into which it enters, and that fraud, vitiates the most solemn contracts, documents, and even judgments. Added for emphasis, and any furtherance would lead to a malicious persecution disguised as a prosecution. Pursuant to Stallings versus Whitaker, the elements of damages in the action for malicious prosecution are the injury to the reputation, character, feelings, health, mind, and person, as well as expenses incurred in defending the prosecution.